She was a scientist. Her entire life was ahead of her. She lived with an open heart and an adventurous spirit. She was the kind of person who wasn't going to let anyone hold her back.
Any reaction to the comments made today, Mr. Dutkiewicz?
No, sir.
But sadly, this man stole her life and her future, chasing her down with her own gun. We'll take a look at why this man turned to murder and the very unique defense that his attorneys tried to sell the jury at trial. And just wait until I tell you what this man searched for online just moments before he shot and killed the victim. We're on The Case, presented by Law&Crime. I'm Chris Stewart. This story is about loss. Not just loss of life, loss for a family, loss for loved ones, loss for society, frankly, because when you look at the victim in this case, she had so much going for her in life. And the person who stole her life, the victim's family says he knew he wasn't good enough for her. This is that victim, Alyssa Wiest. She lived in the Philadelphia area. She was 26 years old, a college graduate. She worked for GSK, that's a major pharmaceutical company. She was a microbiologist. She also loved to travel. She was an inspiration to a lot of people who knew her. For roughly 2 years, this was the man who was by her side, Michael Dutkiewicz. Here's a picture of him having a drink with some buddies. Wiest brothers said that he actually had kind of a reputation of going hard. He did an interview with the Philadelphia Inquirer. He talked about how Michael had been kicked out of bars for drunken behavior. He apparently liked to go drag racing. Alyssa had met him through mutual friends. And again, they dated for about 2 years. But let's face it, from what we can see, Alyssa was someone who was on the up and had a lot going for her. She was working to make prescription drugs cheaper. And it just sounds like this guy, Michael, in the eyes of her family, was just weighing her down. And they believed that she was just out of his league. Now, this relationship in March of this year almost came to an end because Alyssa kind of realized it had run its course, but her sister testified that Alyssa put off breaking up with Michael around March because she was going to go on vacation with his family and she wanted to give this relationship one more shot. Alyssa's brother did say that she was the kind of girl who wore the pants in the relationship. After the vacation in March, once we got to May, she decided that it was time to end things with Michael. And that brings us to May 18th of this year. It was a night where first Alyssa and Michael went out for some drinks, and then they got back to her place in West Conshohocken, Pennsylvania, which is right outside Philly, and she decided it was just time for this relationship to come to an end. It was around 12:30 that morning that neighbors say they heard a scream and then multiple gunshots. When police arrived, they found Alyssa Wiest dead on the ground. She was shot. Not only that, police say they found the door to her apartment open and there was a trail of blood leading to her body outside. Neighbors also told police that they saw the suspect, Wiest's boyfriend, Michael Dutkiewicz, standing by a truck in the parking lot. He then got in that truck and he took off. Wouldn't be long though until he turned himself into police. Police say they used license plate readers to track his Ford F-150 to piece together exactly what happened. Police believe that Wiest had tried to break things off with Michael that night and then she ran for her life. She fought to escape, but she died on the street about a half block away. Now the first shots, police say, were fired inside her home. Police say that they found a suitcase of men's clothing at the home and a cell phone that they also believe belonged to Michael, as if he was packing his things up because this relationship was over. Quote, he knew she was out of his league, and I think as soon as he realized that she was pushing him away, he couldn't cope with leaving one of the best things ever to happen to him. That was Wiest's brother talking to the Philadelphia Inquirer after her murder. Now, Dutkiewicz tried to fight the charges in court, including first-degree murder. He just went on trial, and it was a very interesting defense from his attorneys. Now, cameras aren't allowed in the courtroom in Pennsylvania, so here's video of him entering the trial per Fox 29 in Philadelphia. The station says that evidence at his trial included Ring doorbell camera footage of the final moments of Alyssa Wiest's life. It reportedly shows her bringing Michael's suitcase outside the home. He then says something along the lines of, "Can I get the rest of my stuff?" And to that she said, "You're so dramatic." The two then go back inside her home. It's at that point that prosecutors say Michael searched on his phone, quote, how to load and shoot a revolver. Then, moments after that, gunshots started. The video then shows Alyssa running out from her home and Michael chasing after her. Then the reporter in the courtroom says on that video you hear 2 gunshots, then about a 3-second pause, and then there is a final gunshot that is heard, and that final gunshot, according to authorities, was to Alyssa's head. Prosecutors said that the shots were fired about 25 minutes after Alyssa dumped Michael. The murder weapon was Alyssa's own gun. When you put Michael Dutkewicz's name into truthfinder.com, you do see a bit of a criminal history come up, but they're both traffic issues from what we can see, one including an excessive speeding charge. You remember Alyssa Wiest's brother said he was into the drag racing scene, but certainly nothing as serious as the charges that he faced that led to his trial, that charge of first-degree murder. Now, truthfinder.com is something that we use at Law&Crime. It's a great tool to figure out information about people who are involved in our stories. But even if you don't work in true crime, it can be a great resource to give you some peace of mind because it's one of the largest public record search services in the US, and with the paid subscription service, you get access to unlimited reports about almost anyone. And right now, you can get 50% off your first month of confidential background reports. Just go to truthfinder.com/OTC. At trial, Dutkewicz's attorney tried to argue that this wasn't premeditated though. This wasn't first-degree murder. It was because Michael was in such a rage because he had been dumped. That rage replaced reason. Kind of the heat of passion defense. But the jury, they didn't buy it.
Any reaction to the comments made today, Mr. Dutkiewicz?
No, sir.
Any remorse?
It took the jury only about 45 minutes to reach a verdict. That's it. Michael, guilty of the charges, including first-degree murder, and in Pennsylvania, that is a mandatory sentence of life in prison. Although Alyssa Wiest's life was stolen from her, her legacy is leaving a mark on others who are hoping to change the world as she did. Her family launched the Alyssa Rose STEM Foundation and Scholarship Fund with the hope of inspiring and helping the next generation of young women going into the fields of science, technology, engineering, and math. Joining us now from Pennsylvania to talk about this is Matt Mangino, criminal defense attorney and former prosecutor. It's always great to talk about these cases with you. This one just incredibly sad when you think of the loss of life. Alyssa Wiest, she had so much going for her, and then this man just took it away. Interesting defense. It wasn't really a whodunit kind of case. It was more of the heat of passion defense. What do you make of the argument that, you know, he was so angry from being dumped that kind of replaced reason in his mind?
Well, I think that's really the only option they had here, Chris. I mean, the evidence was overwhelming in terms of, did he in fact, carry out this crime? And I think that's really the only approach that the defense could take. But in Pennsylvania, as in many states, the heat of passion has to be something that happened almost spontaneously with the alleged breakup in this situation. So I mean, to be a bit graphic, if someone faces this kind of situation where they found out that their spouse or their girlfriend or boyfriend was cheating on them, or in this case wanted to end the relationship, if you act out immediately, you can say that, hey, in this heat of passion, I committed this crime. I'm responsible for it, but I'm not, there's a mitigator here. I'm not, this wasn't specific intent. I didn't plan to carry out this murder. It happened spontaneously.
If someone's facing first-degree murder, like Dutkiewicz was in this case, if the jury somehow sided with this heat of passion defense, like what would happen? Is that just a not guilty and he would walk free?
No. What it is it would be a lesser offense. So I think here, in fact, the defense argued for third-degree murder in their closing argument, which is murder with malice. The key difference between first and third is, first-degree murder is automatic life without parole. Third-degree murder is punishable by 20 to 40 years. So, it's substantially different in terms of the penalty. In a lot of cases, if it's a heat of passion defense, it could even be lowered to manslaughter, which is essentially an accidental killing, that there was no intent to kill, but this person was blinded by this insult or this attack on themselves, which, is a breakup or a cheating partner. And therefore, it can be even a lesser sentence.
And with this defense too, where from what police had said, he gets broken up with. He then searches on the phone and kind of like breaking down this defense. Like, let's start with that. I mean, if there's this, Google search of how do I load a revolver, and then he uses a revolver on someone, does that eliminate potentially the heat of passion defense? Because it wasn't really spontaneous. Then you suddenly went in your mind to planning, it seems, this murder.
Well, the key distinction, Chris, is reflection. So you have a moment to reflect on it. So it's one thing, someone gives you bad news and you lose it, and you reach out and you grab that person and you harm them, kill them. It's another thing to go look for a gun, find the gun in a drawer where you know it's being kept, look up on the internet on your phone how to load that gun, walk downstairs and open fire, and then follow that person down the sidewalk and shoot them while they're laying prostrate on the sidewalk, shoot them in the head. That negates, any spontaneity. That negates any act of passion. That reflection that existed there makes this a first-degree murder case.
Because even if it's, just thinking of it as a revolver, I mean, if he loaded the revolver and you take the, you're putting a bullet in and you're spinning it around, I mean, that just seems like a lot of steps along the way where even if it happened within minutes, like at any point within those couple of minutes, he could have stopped and just, not done this. The other part too is on the Ring doorbell where you hear these gunshots and there's like a 3-second pause, and the final gunshot, and this is where it gets morbid and it's sad, was to her head. Even then, that 3 seconds, like, is that long enough to say, and I believe the medical examiner did believe the gunshots before is what would have killed her, but even in that moment, those 3 seconds, how could those have factored into whether he'd be guilty of a premeditated murder of first degree?
Well, in Pennsylvania, for instance, to prove the specific intent to kill, you don't have to have a plan. You don't have to lay in wait. This isn't a case of premeditation necessarily, because you can premeditate in a matter of seconds. I mean, if you point a gun at a vital part of somebody's body and you pull the trigger, that's enough intent to prove first-degree murder in Pennsylvania. So here, when he shoots her, she obviously falls to the ground. Essentially, when he walks up to her and points a gun at her head and pulls the trigger, that's an execution. That's enough premeditation to put anybody away for life. Or if the state has an active death penalty, to sentence that person to death.
How common in domestic violence cases, because in those cases, the murders, sadly, are often so emotionally charged. Maybe it's a breakup, maybe it's a fight for whatever reason. How common is it to see this heat of passion defense when there is overwhelming evidence that the person who is accused of murder actually did it?
Well, it is common, especially in domestic cases. I mean, I tried a case in a neighboring county a couple of years ago that was a first degree murder case. A husband had killed his wife, and we raised that issue of heat of passion, and ultimately my client was convicted of third degree murder. So it's not uncommon, because often these domestic situations are charged, emotionally charged. There's, this isn't a random shooting. This isn't a drive-by shooting. This is something that's charged with passion in and of itself. The ending of a relationship. Certainly, the normal reaction to that should, if you really feel bad, is to go upstairs and cry about it, not to get a revolver, not to look up how to load it, not to come downstairs and start shooting, and then ultimately shoot the victim when she's defenseless laying on the ground.
I guess they had gone to the bar and they only had 2 rounds of drinks. So, and it sounds like he was a pretty heavy drinker. So it's not, assuming his tolerance, 2 drinks wouldn't really do much. But had he been inebriated, is that a defense in some of these cases that you can raise, is that he was so drunk he had no idea what he was doing?
Well, what happens is intoxication, if it's involuntary, Okay, it can be a defense, but voluntary intoxication, consuming alcohol, at a bar on your own, is not really a defense. What it could potentially be is a mitigator, which means again that it could lower the ultimate conviction. So somebody could say, well, okay, he was impaired, he got drunk, he was presented with this terrible evidence. Well, we're not gonna find him guilty of first degree murder because of that, but we're gonna find him guilty of third or manslaughter. So alcohol can be a mitigator unless it was involuntarily consumed, and that doesn't happen very often.
The jury in this case, 45 minutes might be one of the quicker deliberations I've ever heard of in just cases that I've covered. I mean, that's everybody walked in quickly and then they're out the door. For the jury instructions, if third degree murder is a possibility, but this person's been charged with first degree murder, like what typically are they looking at where they come back and he's been charged with first degree murder, but then they still understand the third degree and the manslaughter options? How does that work in Pennsylvania?
Well, if the judge charges the jury on these lesser offenses, which typically the defendant would want those included in the jury instructions, so the court, what happens is that the verdict slip goes back to the jury, and so you start really with the first degree murder, and are the elements of first degree murder present here? And if all the jurors are satisfied that it is, then right off the bat, that deliberation is over. And that's what happened in this case. They all agreed that the elements of first degree murder were proven beyond a reasonable doubt, and they didn't have to go any further. Now, if there was some debate on first degree murder or some dissent on first degree murder, then you might go down to a lesser included offense like third degree murder and see if you have consensus on that. So there's a process, but I assume, these jurors, as you said, Chris, 45 minutes is not a long time when you're talking about first degree murder. I mean, this isn't a shoplifting case. This is a serious case where potentially you're going to put a person away for the rest of their life. So they were so convinced that they probably went around the table a few times, said, hey, is this what we all agree to? Or here's the elements. Do you see these elements as being present? You want to wait around for lunch, or should we tell the judge right now that we have a verdict? That's kind of, what I think happened in this case, because 45 minutes is a very short period of time to deliberate on first degree murder.
Have you ever had a case that short in the deliberation for something so serious?
No. I've no. You typically, the first degree murder case, if it's, if there's some issues that jurors have to resolve. I mean, in this situation, these jurors, they had to resolve that this wasn't a heat of passion. Intoxication really had no impact. And, we find all the elements here for first degree murder. To do that in 45 minutes is pretty quick.
As far as I know, in Pennsylvania, it'll be a life sentence, no chance at parole. In some states where there's the death penalty, Pennsylvania isn't one of them. Like these, it feels like when you have a lot of evidence, like the prosecution did in this case, they can hang the death penalty as something to force a plea deal. Was there any sort of plea that potentially could have been made where, I guess the better question would be, like in Pennsylvania, a state without the death penalty, do you see a lot of these cases go to trial because he might as well try because he was going to get life either way?
Well, yeah, Chris, you're right. Pennsylvania sort of doesn't have the death penalty. Okay, so Pennsylvania has the death penalty on the books, but there's been a moratorium on the death penalty. Governor Shapiro's come out saying that morally he thinks there should be no death penalty. Pennsylvania, they've executed 3 people in the last 30 years. It's been 20 years since they've executed anybody. So you're right. For all intents and purposes, there's no death penalty in Pennsylvania. But that doesn't mean that prosecutors don't seek the death penalty for the very reason that you said. It can obviously be a bargaining chip in a case like this. But I think here the evidence was so solid that there was probably no plea except to life in prison. And so if all they say is, hey, you can plead guilty to life in prison, well, that's the worst that can happen to you. So you're going to roll the dice and see what happens. You're going to put it in front of a jury. The other thing is, this case went to trial in 5 months. I mean, there was a verdict in this case in less than 5 months. That's really unusual. I mean, certainly in a first-degree murder case. I mean, normally you're going to have motion upon motion. You're going to have pretrial hearings. You're going to ask for changes of venue. All kind of things are going to happen in this case before it goes to trial. In this case, the crime was committed in May, and the trial was concluded in October. That's extremely fast to charge and prosecute a first-degree murder case.
I'm happy you brought that up because I forgot about that. The first time I had read this story, I was like looking at the byline to be like, this had to have been a 2024 case because it just seemed like it was so fast. But it was 2025 of this year in May that all of this happened. Why wouldn't there be a pretrial motion or so? Cause, if you're his defense, like maybe you try to get the Ring doorbell thrown out, maybe you try to get the Google search history thrown out. Was that just a case where it was just so solid that there just wasn't much they could do?
Well, I can't speak to the history of the case specifically. I would think if there were pretrial motions filed, there would have been more time would have passed, to get those decisions. You're going to have a hearing, you're going to have testimony, the judge has to make a decision. I don't know if that all happened in a very short period of time, because typically in Pennsylvania, you get charged, you have a preliminary hearing, then you have what's called a formal arraignment, which is usually a month or two down the road. That formal arraignment period starts the pretrial time limit. So you have 30 days to file your pretrial motions. Then the court schedules a hearing. I don't see all that happening typically in any case in Pennsylvania in 5 months that you can go to trial. Now, on the other hand, the defendant may have said, hey, I just let's go. Let's get this done. And ultimately, the defendant, the client, has the ultimate say. If he doesn't want pretrial motions filed, you don't file them. If he wants to just hurry up and rush this case to trial, then you do what your client wants you to do. You can explain what's in his best interest, but that doesn't always influence a defendant in a situation like this. So we'll ultimately see where this ends, because I don't know if there'll be a direct appeal. You have 30 days from sentencing for that. After a direct appeal, you have post-conviction rights that you can file in terms of your counsel and all the other things that go along with that. So this case may really be long from over, but we'll have to see. Yeah, we will. Certainly a quick verdict. Very sad case. Very, very sad to see someone, she was a scientist, had a lot going for her, taken away by this man. Matt Mangino, criminal defense attorney, former prosecutor. Always great to have you on Law and Crime. Thanks for being with us. Thank you, Chris.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.